Right now, I'm cutting across to Dr. Abishek Manu Sanghvi. He's a third-time sitting member of Parliament, also a leading jurist, somebody who has argued this case vociferously before the bench at the Supreme Court of India for the petitioners. Dr. Sanghvi, it's always a pleasure to have you on the show. Thank you so much for sparing time. Are you disappointed with what the Supreme Court has said today?
I must confess that I'm disappointed. The reason is that I believe it's a historic opportunity lost. It's a historic opportunity lost because the judges seem to have been affected by this huge behemoth of a public antipathy against something which is a kind of a revolutionary reaction against something bad. But actually, if you look at it, just consider, they were asked at the bottom line to read into some parts of the SMA wherever husband and wife is used or couple is used. This could include same-sex persons. Now, that's not a leap of the faith at all. That's not a legal acrobatic which will shock you or stun you. For example, when they read consultation in the Constitution to mean concurrence and thereby took the entire power of judicial appointments, it was a much bigger leap of the faith or a much bigger legal acrobatic.
Sure.
For example, when they read substantive due process as part of Article 14, something which, by the way, our founders in the Constitution had specifically rejected, there was a far greater legal acrobatic than being asked for in this case. For example, when they read so many other things in terms of, for example, basic structure of the Constitution, these are much bigger interpretive leaps that we were asking for. So I'm a little disappointed. Now, certainly the Chief Justice has gone the farthest, but somehow, despite holding the judicial reviews available, despite holding that separation of powers, legislature versus judiciary is not an obstacle, I think the judges have stopped short of walking the talk. What they've given are relatively cosmetic, marginal things. You cannot discriminate in the public. I cannot deny you housing or something, or I will not deny you hospital facilities because you are a couple. In fact, the Chief Justice has gone farthest in the case of adoption, but that will be clearly treated as a minority opinion because nobody else has joined him on that. My point is that you've taken the soft option. And remember, one basic point I want to underline. The heart and core of my submission was that you should not allow discrimination to arise based on ascriptive conditions. What is ascriptive? Ascriptive is involuntary, not by choice. Gender orientation, sexual preference, sexual orientation. Now, here this basic point is arising out of involuntary, not by choice, ascriptive conditions that they haven't answered. The only answer to that would be to recognize marriage. And what's so great about recognizing marriage in the SMA, you're not distorting the act. We said it would be religion neutral. We are not making a distinction between Islamic person or other. It could be easily read to be religion neutral. Already today, as you know, a Muslim and a Hindu can marry under that act. A Christian can marry under the act. It's a registrable marriage. So I think here somewhere there has been a phobia of public antipathy, which really I think is a false notion.
Public antipathy, an interesting argument that you raised. Sir, that takes me to another point that the judges spoke of. In fact, the Chief Justice of India spoke of it. That long judgment of about 340 pages also has a particular section that talks about separation of powers. And you rightly reminded how on various occasions tweaking, different interpretations or judicial acrobatics have been done to do the right thing in the interest of justice. And today, one of the biggest questions which has been there on the minds of the community, in the mind of the petitioners, and everybody who believes in marriage equality is that why couldn't the court really take the leap of faith? Now, that being said and done, it's done and dusted, that judgment is already out. Do you really have faith in the government, or the petitioners really have faith in the government? Because the kind of positions that the government has taken in the past has not really been sympathetic to the cause.
Firstly, the whole point is that had the judges done what we had asked, it would have required minimalistic reading into the SMA and there would have been no leap. That's the first point. Second, the examples I gave are much bigger leaps, taken more easily than the leap asked for here. Thirdly, the government will gladly add these cosmetic soft options in the committee. But there is no way in which substantive right, what are these people looking at? These people whom we represent, petitioners, are wanting substantive equality. they are wanting decisional autonomy. They are wanting the free speech and expression part of their life to include the free speech of expressing themselves as a married couple. Now, these things, you can take it from me. This government certainly not, and few other governments I expect to enact into law. In which case, this is nothing but a will-o'-the-wisp, a call for eternity with no real concrete solution in sight. You are actually affecting their dignity, their right to dignity, decisional autonomy, privacy, and expectation of a non-discriminatory format in a manner which allows them to live their life as equals by not recognizing them as married couples. There has been no revolution and no breakup of society if the SMA, and remember, we limited it to SMA. So today, if two Hindus want to marry outside the SMA, they cannot do it as a couple of the same sex. If two Christians or a Hindu or a Muslim, it's only for those who opt for the SMA, which is in a sense largely 99% intended to be religion neutral, caste neutral, backdrop neutral. In which case, why can't it be for both people of the same sex? It only meant that you read husband, wife or the word couple a little differently.
Yeah. Sir, one point that was mentioned by Solicitor General as well during the course of the hearing was that the issue of marriage equality cannot be dealt with by the courts or, whenever the matter is debated without really touching upon the issue of personal laws. I know the petitioners were very categoric that they don't want to go there. The argument of the centre was that you cannot skirt the issue of personal laws and you have to hear the various states on it. Do you believe that argument has had a bearing on the judgment?
Certainly it has had. But it's a red herring.
Yeah.
I stick to my stand. Just consider what you just said. How on earth does it affect personal laws? If the judges make it clear that a marriage under personal laws is unaffected, if that is so, then the SMA also affects personal laws. A Hindu and a Muslim, or for that matter, even two Muslims choosing to marry under SMA are overriding their personal law, aren't they? Then why is it allowed? That is actually a red herring.
Yeah.
It is, that's why I said it's a Hawa created of public antipathy. It's a whole, ambience created of a huge outcry of public opposition. I don't think it's true. I don't think it exists.
So, my final question to you, while you expressed your disappointment in your opening, comments that you made, are you still hopeful that at some point this would change? I mean, from being called the unconvicted felons by Supreme Court at one point and that historic overturning of that judgment where an unconditional apology was owed, do you think that change can happen yet again?
The world lives on hope. I have no doubt it will change. But also remember, John Maynard Keynes said, in the long run, we are all dead. Now, with 5 judges deciding this is going to be a pretty long run before 7 judges decide otherwise. So, I am hopeful, but I am disappointed. And let me hope that my hope conquers my disappointment, if not in my lifetime, but in the future.
Well, we live to see better times, Dr. Sanghvi. Always a pleasure to get your precious time, and thank you so much for joining us on the broadcast and sharing your view. Dr. Abishek Manu Sanghvi, who led the arguments from the side of the petitioners at the Supreme Court of India, one of the leading lawyers and luminaries, talking about the fact that he's disappointed but hopeful that something that most of the petitioners have said